Lori Ann, do you want to walk us through, this isn't in track change format, do you want to walk us through and just tell us what's different?
Yeah, so the main things that are different are subsection, so it's section 1.4. It talks about when the witness has satisfactory evidence of a person's identity. And this provision, it mirrors ORS 194-240. I couldn't do just a straight cross-reference to 194 because it didn't match up with what we're doing in this bill. So basically it just says that a witness has satisfactory evidence of a person's identity if they're personally known to them, or if the person presents to them some form of identification like a passport or a driver's license and an identification card that is current or expired no more than 3 years prior to the date that the person is signing the document. Oh, military identification also.
Yeah.
Then there are subsection 5. I've added in 5A says that the declarations may be completed contemporaneously with the signing of the document or at any time thereafter. Went through and modified the declaration forms a little bit, just with what the group had talked about last time. Subsection 7 now just has 7A as a blanket that subsection 3 applies to the witnessing of any writing that's required by law to be executed or acknowledged in the presence of a witness. And then subsection B has the exceptions to that. So we've taken out all of the express, this applies to the
right.
witnessing of these particular things. And now we just have the exceptions. So that's the notarial act, the witnessing of a will, or the witnessing of signatures by a circulator of a petition. And then subsection 8 is the catch-all for saying that nothing in these provisions is intended to affect the execution of wills. So specifically with respect to the application of ORS 112-238.
Good.
So that's pretty much it.
Okay. Do we have any comments on the draft, particularly the changes? But this is maybe our last chance to comment on other aspects of the draft as well, but particularly focusing on the changes.
So I got a question about section 8.
Yeah.
Maybe if I read it more carefully, I wouldn't have the question, but if nothing in this, nothing's intended to affect provisions of law regarding the execution of wills, doesn't this whole thing affect the provisions of law regarding the execution of wills?
We're intentionally making it not do that because there was concern among the judges and others that this would create too low a barrier or too much confusion regarding wills, so that we're leaving wills alone in the current non-formality options are available, and then used for other things that have a non-formality option already built in.
Right.
Yeah, okay. All right, fine, I got it.
And the express reference to 112-235, that is that's the harmless error?
Yeah.
Yeah. So, okay, all right. Anything else?
And there'll be explanations, correct, with the notes, so that if there's ever a question of how this applies, if someone did do a remote witnessing of a will, if there's a question of how 8 applies or doesn't apply, there'll be notes.
Susan, I guess that's a question for you.
Yes, I've been taking notes of everything, and the comments that will go with the typical way we do this is I'll prepare a report that will be submitted, and when we submit the bill as written testimony, so it becomes legislative history, and that will explain that we don't intend to affect harmless error. And if somebody tried to do this, then they would have to rely on harmless error because this wouldn't apply.
Thank you.
And I think also in the comments, in keeping with our conversation last week, we should include the list of of acts, the statutes that we itemized in the last draft, where we said that this bill applies to these things, we should include in the commentary a listing of those statutes, just so, I think as we talked last time, for the legislature, they'll know what's included in that catch-all statement in subsection 7.
Right.
Question I had in it's in section 7, or I'm sorry, section 2, the repealer. We had talked last time about extending this to the 2021 session. The way I think some other emergency bills are being extended. And I guess I'd like to have a little conversation about that. At this point, this still repeals automatically 2 weeks after the cessation of the declaration of the state of emergency. I personally, I'd be inclined to, I think this is good policy that could be useful outside just the context of an emergency declaration, but I think it would merit at least revisiting by the legislature, and I think that's the policy about bills that are that would be adopted in the special session. What do we think about that, extending this to a date in 2021 that would allow the legislature to renew this and make it permanent if they chose to?
Would it be a later of, meaning later of this date or 2 weeks following the lifting of the state of emergency?
Yeah, that's a good question. I would imagine, Lorianne, there's probably you probably have a formula, some formula language that you're using for other bills.
You know, I'm actually not sure. I haven't checked in recently with the other drafters who are working on stuff that might be in a special session to see if they've modified the sunset provisions. So I can look into that. I don't know that we would do a later of for the sunset.
Yeah.
I don't know. I've never seen that before. So I'd have to see if that's something that we can do or not.
What's the sentiment of the group about at least extending this to a date in 2021 that would give the legislature the opportunity to revisit and make this permanent?
Good.
Yeah, seems like we've done a lot of work for a bill that might have a lifespan of a month otherwise.
This is Bob, and I guess my concern would be all of the, like we talked about last time, the consent to mental health treatment and the death with dignity statute, and if this is going to be permanent to have, I'm just not sure if the legislature is going to take the time and effort to consider each and every policy decision on the whole laundry list that we had before, even if it is in the notes. And it seems during a regular legislative session, there could be a more thoughtful consideration and input as opposed to the emergency legislation and then the legislature just saying, yeah, let's make this permanent later on.
My guess is, and we could even ask Chana in her staff report to elevate that list of statutes to the staff measure summary, so that it isn't lost in the report that accompanies the bill, but is actually part of the staff measure summary that the committee sees. I don't have any problem with making that explicit to them. I think our intent was to make sure it was clear to them what policy choices they were making, to give them the ability to amend some of those things out. Seems to me if we do that, we've given them fair notice and an opportunity to apply the policy lens to this for either temporary or longer term. Would you be satisfied?
Wayne, this is Judge Burton. I wonder if the commentary could make explicit that there should be consultation with stakeholders who are interested in the consent to mental health treatment, the advance directive, the death with dignity, before or when the legislature continues extending this, so that it's clear that those folks up to now have really not been brought in.
Yeah, I'm not sure. Again, I think that might be a better directive to ask Chana to deal with. I think as the bill is getting prepped for committee, because the report really is intended to sort of explain the bill as enacted. That consultation, it would be something that would happen before enactment. I'll follow up with Chana on that. I'll commit to do that and make sure that she's comfortable that the parties that need to be consulted with are consulted with, or at least informed as this bill moves forward.
Okay, thanks, Lane.
Yep. Fair enough.
So are we wanting to change the sunset date then to after the 2021 session ends, so that if the legislature comes up with something permanent during session, it'll take effect after this one ends, and there won't be a gap?
That'd be my preference.
Okay, so we usually go with July 1, but that would require an emergency clause. Do you want an emergency clause in this? Right now it has an emergency clause, but okay.
Yeah, I think we need the emergency clause so that it takes effect during the emergency, and then the sunset would be July 1 of 2021.
Right, my point is it's going to require an emergency clause on the subsequent legislation.
Oh, yeah.
So,
okay.
And that becomes a political question about whether they want a 91-day effective date, or if they want an emergency clause, or if they want it to take effect, in September when most other things take effect.
Yeah.
So does there have to be an emergency? I mean, is there an emergency after the governor's declaration of emergency?
I think that's the question that Lorianne is asking, because the legislature next session would have to declare an emergency in order to avoid an interruption in this if it has a sunset date of July 1. I don't know. In my days, that wouldn't have been a problem. Are emergency clauses becoming more difficult?
It's becoming a thing. It definitely is something that folks have latched onto. It is a policy call for sure about whether to use it, and I think it's something maybe Chana would be better able to speak to what the vibe is right now on that. But
is there a reason we couldn't just sunset it on January 1, 2022, which is
nope, we can do that.
Legislation out of 2021 would go into effect without an emergency clause?
Right.
Well, what are other proposals stating in their documents? Why are we extending it out that far? Because my concern is that if this truly is temporary and we have it go a full extra year where it's not during an emergency, it becomes routine practice at that point. And then I think you're gonna have more and more situations where in questions of people still doing it virtual witnessing. And I guess, are we trying to create a permanent change, or is this to address the current needs of our current situation? My only concern is that if unless there's a push to really make this formal, and the legislature can do that, why push it out to 2022? Because then all of a sudden that becomes routine practice, and then we all know how hard it is to break some of those habits after the fact. So my concern is, are we creating a bigger mess by extending it out that far, as opposed to saying through the end of this year, or being consistent with other of these emergency sessions legislative proposals?
Yeah, Lorianne, do I understand there are other bills that are doing this?
There are other bills that definitely that have the current sunset provision that's in this, which is based on the emergency declaration and when it ends. I would have to look through what other folks are doing as far as beyond that. I know that there are some other sunset dates that are in there, but I haven't been involved with those bills. It'd be great if Channa was here because she's seen all of that. But I can check with her and find out what's going on and get back to everybody on that.
Okay. For now, could we say maybe January 1, 2022, or December 31, 2021? I guess that would probably be.
It's January 1, 2022.
January 1, okay. Let's try that for now. And if we find that that's out of step with others, we can have a quick check-in about that. But that does avoid the necessity of an emergency clause on a 2021 bill then. And we just avoid that argument.
Lane, I did want to bring something up based off a note that Channa had sent yesterday. It was actually regarding the notary group, but I think it's a valuable conversation now. You know, I am still not sure what the appetite of the legislature is going to be for additional bills in any short session that happens. I think they're going to be very, very focused on the budget, as we all know. So I think that they obviously know we're doing this work, and she did very specifically ask if we would want potentially an opportunity to present to the committees. But what I want to make sure I think the question that Eric had is actually one worth discussing further, because if this group, let's say we did all this work right now and the legislature, for whatever reason, decides not even to consider it, do we want this bill to be something that is available that the commission could work in the 21 session or even beyond, or is this solely for the now, and that if the legislature decides not to even bring it up, that it's just dead? I think I want to make sure that we're all on the same page about that, especially my communication with Channa and others moving forward.
Well, speaking for myself, I think there's enough policy justification for this bill that it's, you know, that it stands on its own, you know, outside of the emergency. The emergency is certainly driving and focusing the need for it, but I think, you know, it has utility beyond just that. So I would hope that if the special session doesn't take it up, that it would be at least eligible to be considered in 2021 as regular legislation.
Good.
This is showing my ignorance. Do we have to have a sunset then if we want this to be permanent?
Well, my understanding from Channa, I think maybe it was you, Lorianne, when we talked, was that any bills that they are looking at, or at least as a rule, bills that they're looking at for this coming special session would be basically focused on the emergency, and they weren't looking at enacting permanent legislation as a rule. Is that what I heard?
Yeah.
I think that's what Channa mentioned.
Yeah.
Yeah, and Lane, this goes back to my experience with the notary group, but what I think they've instructed us to do then, and that bill is already going to be considered by the special session, is to have it, because we're going to have to bring that bill back up in 21. They were pretty clear about that. So however we're going to draft this, that if they do take it in the special session, that it's going to be easily edited just in that sunset provision, that we can bring it back up to the legislature in regular session.
Okay.
What sunset are they using on that one? Do you know, Sandy?
I can look it up really quick and share it. Give me
Maybe
one
we can
second.
be consistent with them.
No, that's actually a good call. Lorianne, I'll send that to you.
Okay.
Who's your drafter on that one?
Marisa James.
I'm Marisa James.
Okay. Yeah, let's see. There'd be a good reason for uniformity there. They're both law commission bills. They're both directed at similar things. Okay. Anything else on this then? We can, or how soon do you get there, Sandy? Momentarily?
Yeah, I'll have this soon. I'm just digging up because it's currently embedded in a larger bill, so I just need to make sure I find the right copy.
But good work. I think we've done a good job on this. Like you say, it's way too much work for it to be just a 2-month bill. Take a second to see if Sandy can find it. Pressure's on. And you are muted, Sandy, or maybe
Sorry.
you want to be muted.
Yeah, I do have it. Give me one. I'm going to email it to everybody right now.
So we need to leave the meeting.
What?
Somebody raise your hand when you get Sandy's email. We'll see who wins, who gets it first.
We're not quite there yet. I just had to
Oh.
get it. I had to get it in the right email. Sorry. Sorry, everybody. I just got to get my list up here. Make sure everyone gets it.
Well, we can talk about it even if not everybody gets it.
Okay, it should be out. And you're going to look at page 28 when you get it.
Anybody got it yet?
I know it's been sent because I just sent it. Oh, wait, did it not?
Tell us what it says.
Hold on. Did nobody get it?
No?
It's very
That
odd.
really
Yeah, I
does
got it.
Okay,
attest.
page 28.
Mine missed the exit on the freeway, I guess. I haven't got it yet.
Yeah, I've got it.
Oh, no. Somebody tell us. I can't.
Susan, do you want to take a stab at it?
I'm still getting the right page, but
Is it that complicated?
It starts on page 28. It's a part of a much larger bill.
and I'm looking for the clause that
Yeah, I am too.
how long it lasts. I mean the sunset.
Should be at the very end.
There it's section 62. Well, wait, which section is the notary section? Section 61 is December 31, 2021. Sections 47, 48, and 55 are repealed on June 30, 2021.
That's the notary.
That's the notary?
Yeah.
Yeah, section 48 is the
Okay.
notary.
That's right. That's right.
Well, there we have it. Is that it then, June 30, 2021? And if the legislature wants to make it permanent, they can attach an emergency clause, or there'll be a 6-month hiatus. This would actually be a good bill that this could actually go in the notary bill, probably as a, well, maybe it depends on a relating clause. All right, let's go with June 2021 then. I mean, it seems like the decision has been made on the other, and I don't know what material difference there would be between this one and the notarial.
So just for the group's information, this bill that Sandy sent around, this is the one that the provisions on the remote attestation would drop into.
Oh, it is. Okay.
Yeah.
Perfect.
All right. All right. Well, then I think we're done. Let's do that, and we'll live with that risk that either we have to have an emergency clause to make this permanent, or there could be a gap. Okay. All right. Then I'm going to.
So it would be the later of June 30th or 2 weeks after.
I think that's probably a drafting issue. Whether Lorianne, you can do that.
Yeah, I'd have to look into whether that's something that we can do. I don't know if is it likely that the governor's emergency declaration is going to go past June 30th of 2021? I mean, right now the courts are, I mean, it's up in
Right.
the air about whether it's actually still effective now. So to be honest,
Yeah,
It's true.
it looks like that decision has been made, certainly in the bill that we're looking at, and I'm guessing in other bills. We'll just go with whatever the consensus is in drafting.
Okay.
All right.
Perhaps
Bring
could,
who's
could
that?
Lori, this is Matt Trump. Could maybe Ledge Council discuss and between the two work groups and talk about what they think is the most appropriate way to address the sunset issue, and then give us a recommendation?
what do you mean by address the sunset issue?
Well, I mean, just as we've been discussing, if for the notary bill, there was the draft that got circulated that says through, I've now closed it, what did it say, through July, or through June 30, 2021. I don't know what discussion they had there, but just as we're discussing about the potential for a gap, it just seems like if you could discuss with Marisa about what you guys think is the best way to approach this and give us a recommendation, that would be helpful, I would think.
So when you're talking about the best way to approach it, the best way to address the gap, any potential for a gap?
Yeah. So,
okay, so
Lane had noted the issue of needing, in 2021, they would need a further emergency clause in order to avoid a gap. And is that okay? Or do you think that it would be, if it's important to the group that we not have a gap, would you recommend some different approach?
Well, that's a policy call, so that's not really something that LC can make recommendations on. And Marisa would have the same discussion that I just had with you, which is saying that, you know, if they do enact some legislation in 2021 that makes this permanent, to have it be effective on July 1, there would have to be some form of an emergency clause. And so that's really a policy call about whether that's something that folks want to do, and we can't advise on that.
Right.
So I think,
yeah, I think just to try and wrap this up, I think I'm okay with June 30, 2021. It's consistent with the call that's been made on the Ontario bill. We're following along behind that. We're going to be in the same bill. And honestly, if there's support for this bill and this concept and continuing it, it seems to me that the risk of a gap would really be the easiest justification for an emergency clause if they want to make it permanent, just to avoid that gap. So,
okay.
I'm about to bring the gavel down on this one, then the proverbial gavel, and say we've got a product here with the change in the sunset clause. All right, great, everybody, good work. This was harder than we thought it was going to be, but I think it's a good bill.
So Lane, just to make sure we're on the same page, I'm going to communicate to Chana that the group has reached consensus. I'm using that word intentionally.
Yes.
And would like this bill considered to be placed as a part of the larger draft bill for consideration for the upcoming potential special session.
I think that is correct, as long as the Law Commission is willing to accept that recommendation and move forward.
Yeah, I'm actually speaking to the chair this afternoon, so I'll bring it up with her as well.
All right, let's get on to something new and different. Chapter 111. Thank you, Lorianne, for your heroic work in getting this draft out.
yeah.
I'm going to grab Chapter 111 off my shelf. Let's take it from the top. I know we started walking through this at our first work group meeting here a couple of months ago, but obviously enough, I think, is different about it now that it probably is worth starting right in section 1 and going through. Jennifer, are you on the call?
Yes, I am on the call.
Okay, good. And Heather, I saw a chat from you, so I know you're on the call. So we've got our authors to defend their work. And let's go. Starting with section 2. Application of the Oregon Rules of Civil Procedure, Oregon Evidence Code, as used in the section contested probate proceedings. So it's a new term. Includes any matter in a probate proceeding where a court orders a show cause or a party files an objection to any other party's petition or motion for affirmative relief from the court. For the purpose of applying the rules of civil procedure in a contested proceeding, plaintiff means any party asserting a claim for relief, whether by motion, petition or motion, or if the court orders a show cause, the court.
Oops.
And defendant means any party against whom such a claim is asserted, or if a court orders a show cause, the party subject to the show cause order. All right, let's talk.
Lane, before we go into all those comments, which I think raise good points, I just had a question where the court orders a show cause. That is a little unclear. Is it a show cause hearing? Is there something else that's needed to make it clear what that is?
Well, as a matter of drafting, I might say enter the show cause order.
Well, it says where the court orders a show cause. So that implies an order.
It should say the court issues a show cause order.
Okay, there you go.
That would be better.
Yeah.
But the courts do that. The court's computers do that when you don't file your accounting on time.
Actually,
I don't know that, John. I that's news to me.
Well, isn't that a good point that when the court's computer issues a show cause for failing to file the inventory on time?
Right.
Is there a window of time during which it's now an adversarial proceeding that then collapses and the ORCP no longer apply once that show cause is resolved?
Well, let's kind of back up and talk again about what's going on here. This is to clarify the application of the rules of civil procedure in the Oregon Evidence Code. We don't want them to apply to everything we file in a probate proceeding. We want those rules to apply to a limited extent. And I guess that's what we're doing here, is creating those circumstances. So yeah, how well have we done?
So Matt's point is a good one. And this is kind of the policy challenge of drafting this. We talked about whether to formally describe when a probate proceeding shifts from non-adversarial to adversarial. And it's not an easy task. So if somebody has a great, simple way to do that, I would love to know what that is.
Well, I mean, we may be close. Except for that, automatic.
Well, this is Judge
Because
Donahue.
it goes back and forth.
Let Judge Donahue, go ahead.
Well, I think we're looking at two different things here, though. When a court issues a show cause, a court's going to issue a show cause because some procedural requirement has not been followed.
Right.
Something hasn't been filed by a timeline normally, an inventory or an annual accounting.
Right.
So that's essentially a procedural show cause. You haven't complied with a court procedure, and so you need to either do that or the case will be dismissed. And those are really your only options. There's nothing really to argue there. However, there could be another show cause where a party, either an interested party or a creditor, I don't know, would file a motion to show cause with the court, challenging substantive decision by a PR. The court then issues a show cause order telling the personal representative, most likely, to appear why this relief shouldn't be granted. Those are two different animals, and I don't think you want to collapse them, because the court never really becomes a party. The court's just monitoring technical requirements with the first show cause. The second, the court is really, again, back in just being the arbiter of a dispute that a party's brought by a specific vehicle, which is a show cause motion. So I would keep those two separated. I wouldn't just roll them both.
I like that. It gets the court out of the definition of plaintiff down below, which is kind of makes me a little bit uneasy.
This is Judge Burton. Can I jump in on that? I
Yes.
think the challenge that we're going to have is that there's going to be different practices in different counties. So as far as I am aware, you know, my county does not just automatically spit out a show cause if some deadline is not met. And while I do certainly issue show cause orders on the motion of a party, I also will issue show cause orders on my own motion, either to remove and replace a PR that's not behaving as I think they should, or oftentimes I'll issue a show cause to close without discharging the PR where I just can't get them to get the estate closed. So I just think different counties are going to have some different practices as far as when they issue show cause orders.
So that is part of the challenge of drafting, is that on procedural show cause, it's not really converting into a contested proceeding.
Right.
But on a substantive show cause, it does convert to a contested proceeding. And the challenge is in those counties that issue substantive show cause orders, how do we keep the court from being a party? I mean, that's part of the challenge of drafting.
Well, I think one of the ways we could do it is, and I agree with Judge Burton, like in Benton County, we don't issue show causes if you don't file your inventory in time. We just send you a notice saying you're going to be dismissed if you don't do it in 30 days, and that's that. And I think a lot of jurisdictions do that. For the own motion show causes by the court, we may be able to just carve that out, which is to say if the court issues a show cause on its own motion, that's not, you know, that's excluded from this from orders to show cause that are issued by the court based on a motion from an interested person or party.
And what you would say then in sub 1, in 1A would be that when a court issues a show cause order on motion of a party or interested person.
Right, something like that. Either do that or just exclude, put some language in excluding any show cause orders issued on the court's own motion. Either way, I think you could do it.
But you do need to have some of the ORCPs when a court issues a substantive show cause order. And that's because it then becomes similar to an adversarial proceeding where the person responding to the show cause order should have some outline of what's expected of them in terms of timeframes and those types of issues.
Yeah, that's absolutely right. And it's also important to remember that there's a spectrum between a procedural show cause and a substantive show cause. I mean, I've seen plenty of substantive show cause orders like the ones that Judge Burton was referring to. I've seen some that she signed. And, you know, there's a difference between, oh, you didn't file your inventory on time and you get an emailed notice the next day, and one where there has been a repeated failure to adhere to the procedural requirements that results in Judge Burton eventually saying, wait a minute, you know, this estate isn't getting, not to single you out, Judge Burton, but I mean, this estate isn't getting administered, or the court becomes aware that maybe there's something behind a failure to honor procedural requirements that may indicate a substantive problem with the administration of the estate. So I don't think that we can easily draw a line between what I'll call procedural show causes that some counties issue and substantive show causes that specific judges issue when they see a real problem with the case. I just don't think that we can address that with specificity in the statute.
Of course, now we're looking at somehow defining procedural and substantive show cause. Thankfully, I really have never been in front of a court on one of these show cause orders, the serious kind, that a court has issued. And so help me out, how does the ORCP, it's just you and the court, it's the PR and the court. How does the ORCP play in that kind of a proceeding? You're not going to get discovery from the judge. What aspects? So I guess maybe the basic question is, why do you need the ORCP to apply in that kind of a situation where it's you and it's one person in front of the judge?
So there's a couple of things that we need to divide in that lane, and then maybe Matt can talk about how the ORCPs apply. One is a case that's exclusively the court and the fiduciary, for example.
Right.
And another is a case where the court issues the show cause order. The fiduciary is aware of it, but there's other interested persons who then begin to appear. Because in that process, everybody has a right to be heard. And so the challenge is knowing at what point another interested person is going to show up.
Well, and then also, I think there's a situation, I had one where the judge required notice to the beneficiaries of an estate because they didn't know what was going on. And that's an important part too.
Sure. Let me sort of jump in and suggest reasons that, that a show cause issued by a judge would require the ORCP and the evidence code. So, for example, you can get, as a PR, you can get show cause by the court for failure to do your job. You may need more time in which to respond, so you need to move for an extension of time under ORCP 15. It could be that you need to do your job, but you haven't been able to do so because you actually need to be able to use some of the discovery provisions under the ORCP to get information from other people to do your job. You may want to be able to issue subpoenas, and of course there's no clarity about whether or not you can issue subpoenas absent an adversarial proceeding.
Okay.
The places where I see it come up most frequently is what Matt said, and that is when the PR is trying to get information. We don't have a statute similar to ORS 125 that gives the court powers to order things like documents be delivered or the person be delivered. Those are some of the things that are missing in ORS 111 that are important to PRs when they have non-cooperative parties.
This is Judge Burton, and maybe it's not in 111, but isn't there a statute somewhere that says the PR can make people show up and produce records? I seem to remember that as existing.
Yeah, I believe that's 114.425, where the court can order a person to do certain things.
Right. So Judge Burton's question, I guess, is in light of that, at least for that circumstance, do we need the ORC? Do we need ORC? Do we need ORCP to do that?
Well, there's a lot of not a lot of, because there are only like 3 of us who talk about this stuff. But 114.425 and what it means and what it allows you to do is a topic that some of us disagree about. I do read 114.425 to permit the personal representative to seek authority from the court, to in effect, to cause somebody to show up and give testimony in a courtroom as necessary to get information about the property of the estate, etc. What it isn't is authority for a personal representative without more to issue subpoenas or to command somebody to show up for a deposition in a conference room, if indeed we ever do that again. So, so making the ORCP apply would make it a lot clearer what the personal representative, or rather what parties within a contested probate proceeding can do, instead of me and the other people who fight about this stuff disagreeing about what 114, 425 allows or doesn't.
And the problem with 114 is that it allows you to get a deposition, but it doesn't say within that you have to bring all the paperwork. You have to, I mean, it just says a court may order any person to appear and give testimony by deposition. So you're left asking the person questions who says, I don't know, I can't remember.
Yeah, this is Judge Burton. I'm looking at that right now, and I see that you're right. It clearly doesn't give you as much latitude as the ORCP discovery provisions.
This is Lori Ann. So question I have is whether the changes to section 16 of this draft, so that's on page 9, okay. It's subsection 4, if that would resolve the issues that you're discussing.
Page what?
It's page 9, it's section 16, sub 4. And I think Heather and Jennifer can speak better to what the goal of the changes were.
Oh, okay, yeah.
So that's exactly what we were trying to do. We were trying to take not only that 114 statute, but also some of the inherent authority we believe that the court has. And we were trying to place it in statute to make it clear that the court has that authority. I mean, we believe that the court has that authority. They're courts of general jurisdiction, but actually having a cite when you're drafting a document asking a judge to do something, it's very helpful to tell the judge, look, you have the right to do it, and here it is in the statute.
So does that answer the question?
Well, really, that's a question for Heather, I think. I mean, by that subsection 4A under section 16 of the bill, I mean, does that permit, I mean, does that contemplate that a party, whether it's the personal representative or some other interested person who has shown up, does that mean that they automatically get the ordinary discovery provisions of the ORCP, or instead that under, you know, presumably for some sort of showing of cause, the personal representative, absent an adversarial proceeding, could apply to the court for authority to engage in specific, what we would call, you know, civil litigation type discovery actions?
So if we're going back to kind of how we started down this path, yep. And the issue is, you know, do the ORCPs need to apply in a show cause proceeding? I think that the language below that creates more statutory authority for people to act, I think that that's separate and apart from the need for the ORCPs. The reason I think that we need the ORCPs is because, for example, if we want to use a subpoena to get bank records, when we can, under the new language, we can ask the court for an order requiring the bank to disclose the bank records, or we can use a subpoena under the ORCPs. My preference is to use a subpoena. It's far less expensive to the estate. So I think there's arguments for keeping ORCPs in substantive show cause cases.
Yeah, that would be a difference because on the language of on page 9 and 10, it is a court order that's causing this to happen. Under the ORCPs, you can do that by issuing your own subpoena. So that is a difference.
I think the goal that Jennifer and I had when we were drafting this was a lot of things happen in probate that aren't in the statute. And it's always kind of this judgment call. Like Matt said, there's this small group of nerdy folk who like to talk about what and when subpoenas and other things apply. I'm not in that lofty group, thank goodness, because I ask people like Matt and Brooks, okay, what do you guys think? And they're right to be concerned. When I listen to them, I understand what they're saying about the basic concepts of contested cases. And so as we consider what to bring in from the ORCPs into the statutes, the biggest issue is when we become a contested case, it makes sense for some of the ORCPs to apply, but our challenge is that the concepts don't fit the same way. And so in this section where we're talking about when a case becomes a contested probate case, what applies? That's what we're talking about. And so here we've talked about, I think that it's difficult to say that the court becomes a plaintiff. And maybe we should break that paragraph out into like a C about what happens when a show cause order occurs.
This is Judge Burton. What about just something that says the court does not become a party for the purposes of ORCP when the court issues a show cause on its own motion?
Well, but that wouldn't allow the ORCPs necessarily to apply in that situation, which I'm hearing could be a good thing.
Well, it just says the court doesn't become a party.
Right.
It doesn't preclude it from applying to other parties. So if I issue a show cause on my own motion and then an heir shows up and says, I want records, or the PR wants records from an heir, they could still do that.
But
They just couldn't serve. They just couldn't serve me with a records request.
That's right.
Of course, they also have the Public Records Act, but that's another story.
If you look at section 2(1)(a), what we're looking for in this section is to define when a case becomes a contested case.
Right.
That's what we're looking to define.
And that is critical to this whole concept.
And so if we're looking to define when a case becomes contested or when certain sections of the ORCPs should apply, at what point is that? We're trying to identify a point in time when it becomes contested. And then as Matt said, we probably should also clarify when it becomes quote unquote uncontested. But, if we want to, we could add what Judge Burton suggests, C, which is the court doesn't become a party, but that seems to be that's such a weird thing to say because the court really shouldn't ever be a party.
Right. We may just take the court out of A or of A.
Well,
okay, let's back up. Let's back up. The big picture. All right. If someone files a will contest, we want the ORCP to apply to that. If someone files a petition to have the personal representative removed, we want the ORCP to. Those are easy. We're getting into the hard cases.
Would this work?
Can I weigh in for a second?
Please.
Sorry, this is Jeff. Just as someone who sees a lot of the pro se objections and contested filings, I don't know that you want the ORCP applying to everything. A lot of it doesn't make sense in the context of probate filings, even in contested proceedings. And in terms of the whole conversation about a court becoming a party or wanting the evidence code or the ORCP to apply when the court is requesting proof, documentation, or other information about what the PR was supposed to have been doing. I've never seen a judge hold a party to like the evidence code for explaining why they stole a bunch of money. It's almost always a lower standard. So at least from the court side of things, as someone pushing a lot of the paper, I'm a bit concerned about drastically altering what everybody's accustomed to. Go ahead.
Sorry, Jeff. When the court's the only party, you're entirely right. But sometimes in those show cause cases, the court's not the only person. So in those cases, they kind of shift, right? I know, I get your point about pro se. In probate, we have so much pro se.
Would it work?
So,
hold on, let's get Jeff's response.
well, there's a difference when you have a person appearing and, you know, paying a filing fee and then putting skin in the game, and when you have like a PR show causing a squatter who's not really related to the case, but, you know, affected by the outcome of a hearing. I don't think any of the judges consider it contested if you are show causing a third party, but once someone has appeared in the case with a position opposite the position of the PR, then it's obviously contested. And I think most judges are looking at it as contested as to the issues that are raised by a party to the case.
Jeff, this is Matt. You may be a little spoiled.
What'd you say?
You may be a little bit spoiled, just in that the judges in your county get enough of a volume here that they have some experience, that they have enough experience that they aren't making ad hoc decisions based on situations they've never seen before.
Sure.
So all I mean to say by that is that, you know, when I've gone to some of our further flung, less populated counties, you know, I've many times gotten in fights about what the procedure is, and, you know, what is the shape of this contested proceeding, and that, I think, is the problem that we're trying to address here, which is to impose some uniformity so all judges statewide sort of know what, you know, what's happening here in Section 2 is Heather and Jennifer are trying to make it clear when we jump into the sandbox of ordinary litigation and when we jump back out and go back to the more free-form, flexible procedures that various courts have developed on their own.
Sure. And I guess my question is whether you want, you know, if an opposing party shows up, pays their fee, and contests something, does the notice and time to object framework go out the window in exchange for the ORCP framework? And does that then only last as long as it's contested? Or does it take over, like,
I get what time frames apply. That becomes the issue. What time frames apply?
Sure.
And that's a serious problem.
And at least with the NOTO, the notice of time to object thing, there are a few fixed time frames in which you're supposed to respond, you know, to something that you may or may not agree with. But we start seeing things like a motion for an order to allow amendment of a petition for a second time. That makes sense under ORCP. It doesn't make a ton of sense in some probate cases. Maybe I'm not making a good point here. Everyone's silent, but.
Who else has
This
experience?
Is Brian.
Who's that?
This is Brian.
Yeah, Brian.
I think part of what Jeff might be getting at is that in some counties like Multnomah, they file up to 15 of these show cause hearings a day. And it would be pretty cumbersome if all of the ORCPs were to apply to all of those instances. I could see that being a real drain on court resources.
They don't, and that's why there's those exceptions listed in Section 2, what ORCPs do and do not apply.
Would it work to clarify this, to have the court order when it applies, and a party could ask that the ORCP applies?
That's what I was wondering.
Yeah, but the problem with that, Jennifer, is so you have a petition, you have an objection. Who prepares the order saying, okay, now the ORCPs apply? I think it makes more sense to say it needs to be statutory or automatic.
Well, you could
and
have some
also
automatic. You could have some automatic, and then for these cases where we're really struggling over, where it's unclear, have it be that the court can order or not. Like when you have 15 show cause orders, the court could just say, you know, wouldn't issue the order saying that the ORCPs apply, and then they don't.
So this is Judge Burton, and while I love having unbridled discretion, I think just tossing it to the court to decide, you've got to give the court some standards or criteria on which to make that decision, and then you're kind of right back to where you already are.
So this is Judge Cobb. Could it be that on the motion of a party, or, I mean, leave it up to the court? If the court just wants to jump in, they can. If they don't, then that's fine too.
So say something like, upon the filing of an objection or upon the motion of a party, the following shall occur. Is that the suggestion?
That's kind of what it sounds like to me.
Well, under this construct, would the ORCPs automatically apply to kind of a classic contested proceeding where you've got the filing of an objection or, you know, petition seeking, relief against another person? Is it just these more complicated cases, maybe court-initiated show cause where now other parties are wandering into the thicket, that we would need to give the court discretion to apply the ORCP? I don't know.
Because one of my concerns is that it's not unusual to file an objection simply to reserve your right, because you have the time limit. So you file an objection, see what we're sorting out here, and frequently it never comes to anything.
Well, there's also objections to the entire proceeding that we see, and then there's an objection to a particular course of action taken by the PR. So like maybe the PR is trying to sell some real property and someone contests it because they want to live there or whatever. But we also have these people showing up saying, I object to this entire proceeding. And it's the scope of something like that is impossible. I mean, like, well, yeah, it's not someone who hasn't died objecting to their estate case, but like, sometimes it's the disinherited son who's like, this is all fraud because of my sister or my brother or whatever, and none of this should be happening, and my name should have been on all of it.
Yeah, if we try to solve some of that it's Heather, we try to solve some of that by saying what the objection must include, even if a person is pro se. That's our goal. I mean, it's true that we want to have access to justice, no question, but at the same time, this is a lawsuit, and there needs to be some formality because of the consequence in terms of cost and waste of judicial resources. So we did try to clean up some of the objection stuff.
To the extent.
Yeah, it's.
Sorry.
Oh, I was just going to point out that some people, object to an accounting in 1 year and then object to the next accounting in the next year and the next accounting in the next year. And the scope of the objection is never really resolved because it's clear that they have some underlying beef with the entire case. And they're just trying to waste everybody's time at that point.
Let me just posit a question for kind of step back a little bit on this and ask if in trying to solve, I mean, are we making probate more complicated? Maybe less clear, but is this going to make it more complicated? Probate practitioners who don't litigate all the time, tell me.
Well, here's an idea.
John?
I think I litigate some of the time, sort of. I'm in the back row, but
I heard
think
that.
He's in the front row. I think there's just a fundamental conflict here between trying to view probate court as some sort of family counseling session, helping people sort out their own problems, and dealing with the more complex cases where there are real lawsuits and there are real interests involved. And it's really, in everybody's best interest for it to be handled in a professional manner. So you can't, it's kind of hard to write the rules in a way that preserve the little people filing objections in the back of an envelope and still allow a structure for people like Brooks and Matt to do real litigation in a real court. So I think we have to just pick one, and I favor making it more professional because the stakes are so much higher. And as we go by, the cases in probate court are more and more substantial. So you kind of want a real lawsuit with real litigation rules.
Let me ask, and this goes back to something, Jennifer, I think you suggested a different take on it, but do we have, John, your comments well taken. It's, some of these things really should not be dealt with through the application of the ORCP. It's just get the judge and the people in front of the judge and have the judge work things out between them, and that's what we want. What if we approach this in something like a motion to have a case declared complex litigation or something, that triggers certain consequences that flow from that, but it's always initiated by a motion and that shows to the court why this proceeding now has become something that is complicated enough that everybody needs the guidance, they need the protections, they need the assurance of the rules of civil procedure, but do it on a motion basis. What do we think about that? And I guess I would need to look at whatever the rules are about complex litigation to see what kind of analogous things, because Judge Burton's going to say, well, yeah, what do I use to decide if it's complicated? And that's a fair question. But is that approach, would that be better in that it wouldn't just implicate every objection that gets filed on the back of a napkin, into this procedural morass?
So Lane, this is Brooks, and I'll chime in from the front row of the litigation department. I think there's a lot of merit to that idea because we already have certain things where it is obviously, I'll call it, serious. I'll say serious litigation. A will contest is always serious litigation. Right. Petition to surcharge a PR, always. Things like, I object to the accounting because I wish I was PR and I'm going to do it for the next 10 years until the probate's done. Those are of a different category. So my thought would be, what if we came up with a list of all the things that are already known to be serious, list them in a rule, and then give the bench discretion for good cause shown to consider other things serious? Maybe I'm objecting to the first annual accounting because there's all these things going on in the corporation owned in the probate that you don't see in the accounting, and you need to know that, judge. And so instead of making people do it every time, we predefine this thing, that thing, that thing, and then we give discretion to do the other.
Yeah, I think I like the flavor of that. What does everybody else think?
So something like a contested probate proceeding includes but is not limited to will contest, surcharge, removal, and the not limited to is somehow delegated in specific instances to be triggered by a judge on order.
That was what I was thinking. Yeah.
The only thing, I don't have any problem with that, except that there are circumstances where a party needs immediate relief from the court. For example, the PR is not paying attention and is selling a specifically devised asset. and escrow, the way that the devizee finds out about it is because of escrow. I mean, sometimes you need some of the temporary relief provisions in the ORCPs.
Heather, I think that the temporary relief provisions in the RSCPs are exactly when you, that's exactly what you don't want in the situation that you're describing. The sort of emergency TRO provisions that we find up in the 70s in the ORCPs are incredibly burdensome, hard to administer, and expensive. And it's when the PR is selling specifically devised property and the beneficiary finds out 3 days before escrow is to close, that's when you don't want to be locked into the ORCP. That's when you want to be able to rush into Judge Burton's chambers with your hair on fire and say, oh my God, oh my God, oh my God, solve this for me.
Yeah. Let me just.
Well, that works great for lawyers like you and me, Matt, because we know who to rush to. But yeah.
Let me note for a second, Gretchen's microphone is not working.
Is it now?
Oh, yes, it is.
Okay. First, I think I figured it out. You guys know I'm technologically deficient. I admit that. I mean,
oh, go ahead.
If you're not going to want it to apply to everything, then I think treating it like a designated, like this is, you do a class certification. It's a judge making a decision. This is appropriate, upon motion. This is an appropriate certification. And as long as it's clear and people understand that, then I think that's fine. And I would support something like that if that's how you all want it to go. I agree with Heather that there is an issue for the people who may not, again, you're going to have counties where you have people and judges who know what they're doing, and in other places where it's not something that happens very often. And so maybe you do want to think about emergency situations, and you could still have that be worked into it so that you can make a motion, ask for a shortened timeline for consideration by the judge, and get it moving. And I think you could solve it that way. But, this is a middle ground that I think it can be effective.
Well, Gretchen, would you support sort of a list of types of proceedings in which case the ORC will always apply?
Yes.
Okay, and then some sort of more general statement that it will also, on showing of good cause, and we can look at class certification or complex litigation and see what kind of factors are at play there. Allow a party, a person, and we don't always use party, allow someone to ask the court to say that the ORC is going to apply to this. And then it does.
So we need to revise section 2.1 to describe when a contested case occurs.
Yes.
And then within each contested case, when it becomes a case to which the ORCPs apply.
This is Brooks, and I think this is probably the point where Matt and I volunteer to take the first stab at that. I think we are the sacrificial trial lawyers on the call. With Heather, sorry.
So
I love it. You guys can do it. It's all yours. I'm not territory.
All right, you heard it. Heather's the chair of the committee.
So and I'm happy to have somebody take a lead on this. But so I thought I heard something that I hadn't picked up on before. You have a contested proceeding, but that may not trigger the ORCP. There has to be something else beside it being a contested proceeding that triggers the ORCP. And I'm talking here about the proceedings that would be categorical.
I was thinking, Lane, what I'm using the shorthand, the serious cases are defined as ORCP. That's the will contest, et cetera.
Yeah.
And then anytime anybody's asking the court for relief, and in the hypo that I think Gretchen or Heather was using, if the beneficiary just says, look, don't let them sell my specific device because they don't need the money for creditors, maybe we don't want to be issuing requests for admissions there unless the court thinks that's a good idea. We ought to just show up, talk to a judge on a show cause and be done. So that would be one of the everything else, if I could come in with my beneficiary and say, no, 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 Judge, I need to take depositions because look, you know, they're liquidating a $10 million corporation. It's not what you think. This isn't a residential house sale. You know, I like the flexibility because we can't, you know, we can't predict.
Well, then do we want to authorize Matt and Brooks as a thought group to try and work this section out, and maybe then we can go on?
I think that's a great idea, but I think you have to be really careful about the definition of contested proceeding because it's used throughout the statute. So you have to kind of, when you're defining that, look throughout the chapter and think, okay, is this definition going to work with the use of the term elsewhere?
Yeah, well, that'll be their challenge.
Yeah, that was something we faced on the Council on Court Procedures all the time. So I'm not saying it's easy, but I'm saying I've trod that ground before.
I am totally in favor of Matt and Brooks taking a swing at this. This is a really tough area, and I think a small committee makes a lot more sense than all of us because
yeah, especially a committee of people who deal with this.
Yeah, and then we can look at it as practitioners. I sort of do litigation like Drania. Sometimes I'm at the table, sometimes I'm in the back row. It depends on what's going on. And I just feel like I have seen enough cases where I would welcome the ORCPs and the elimination of the question.
All right, let's do that, because otherwise I think I think we've raised the issues. We're not going to solve them here. We'll give Matt and Brooks an opportunity to do that for us, or at least guide us in our next discussion of this. And I think that takes care of
Judge Cobb, could Brooks, in your discussion, you and Matt, is there going to be room for the court? I have two pro ses that I really need to have some ORCPs imposed on them, so the court would be able to do it on its own motion?
I see no reason to restrict the discretion of a judge. I spent 8 years on the council saying that all the time. So that's a great idea, Judge. I hadn't thought that. We'll make sure we put that in our first draft. Yes.
Thank you.
All right. Good.
And this is Lori Ann. Matt and Brooks, if y'all want to loop me in on that, if you need to, please, that's fine. But one thing to consider, I know we touched on it briefly, was when the contested part of it ends, having that defined in what you're drafting too would be helpful for when the ORCP stops applying to the rest of the proceeding.
Good points. I'm making a note.
Okay.
Do we want to look at 2, 3, and 4, or shall we wait until Brooks? I'm looking at in section 2, or do we want to wait until Brooks and Matt come back?
I think that we can start to talk about some other things and more effectively use our time.
Okay. All right. Let's go on to section 3 then.
Okay. So section 3, so you know what the concept behind it is many times we're aware that people who are financially incapable or are minors are receiving notice. And the challenge is, how do we solve that cleanly? And right now, certainly the most direct way to solve that is by applying to the court to appoint a guardian ad litem. And under the old guardian ad litem statute, that was a pretty short and simplified process, which was good and bad. It was good because it was short and simplified. It was bad because a lot of times people who should have been noticed about the appointment of a guardian ad litem with powers and controls were not noticed. So now what we're thinking about doing is expanding that a little bit to also look like ORS 130, the special representative statute. So this is really a policy question for us. Do we want it to be as simple as the ORS 130 representation statute, or do we want to retain only a conservator or a guardian ad litem? That's the question.
This is Judge Burton. I love the special representative idea.
This is Brooks. The only thing that I think is currently a little bit lacking in the spec rep that is also a little bit lacking in the guardian ad litem and the ORCPs. This came up in a case I ended up trying in Washington County, where there is currently no requirement that either of these fiduciaries have any skill or experience in whatever it is they're representing the person for. And I wonder if that's worth adding in, or does that just add complexity? You know, is mom the best representative for the kid when the estate issues are very complex? Do we depend on mom to hire competent counsel or to live and die with who she hires? Or do we impose some knowledge or experience requirement? Not sure I like that, just throwing it out there.
So clearly in the special representative statute, there is that ability, that special knowledge provision.
Yep.
And I like that because I've found it to be helpful. I think that a lot of the lawyers who do PI work, they choose mom or dad because mom or dad is who has come to them. And in many cases, mom or dad are the appropriate guardian ad litems. But I don't know that it's mom or dad is always the appropriate guardian ad litem in probate. Sometimes they are. If it's a specific bequest of $25,000, you want a special rep because it's way cheaper. You know, everybody understands, okay, $25,000 is $25,000, unless there's other complexity to the estate that makes it something like it's not because of abatement or something.
So we actually have something like that in the draft. It's on page 3. And it's subsection 4 on page 3. It says a person appointed as special rep must have appropriate skills and experience necessary to adequately represent the individual, and also that person can't be related to the PR or a beneficiary or a person with an interest in, should be the estate.
Yeah. Okay.
So one of the other policy questions that Lorianne brought up was a good one, and it's the policy question of the right of parents, plural, to know about the appointment of the special representative. And so I have had numerous estates where there's a gift over to grandchildren, and the testator would have been extremely upset if former daughter-in-law or son-in-law was aware of what was going on in grandparents' estate. And so Lori asks the question, who's entitled to notice? Who has inherent rights? And those are good questions for us to talk about as public policy matter. Parents don't inherently have financial rights in Oregon. They have rights to notice, I believe, but I don't think that they inherently have the ability to exercise financial rights on behalf of a child.
Well, notice comes up in section 8 below.
On Heather's direct point, I can chime in. I've researched and litigated the heck out of that. I think there's no question mom and dad, purely in their capacity as parents, even if they're the custodial parent, don't have authority to transact financial business, bring litigation, or anything else on behalf of the kid unless they're appointed to a fiduciary role. So I think that's a correct statement of Oregon law right now.
Well, let's save that for section 8, because we'll come up to that question of who gets notice. But just looking at 3, we have the option here of a guardian ad litem or a special representative. And we deal with that in section 6 in more detail below. And then the provisions in 2 and 3 that the guardian ad litem or special rep can represent more than one person. There's no conflicts. And that the court shall state its reasons for appointing a guardian ad litem or special representative. Any further questions or discussion just about what section 3 does on its own, without getting into the details of the appointment or notice, which will come up as we go through this?
I'll just chime in that the special rep statute in 130, and as it's imported over here, is both more powerful and more flexible than the GAL construct from the ORCP. As we've observed a lot of times, a guardian ad litem is authorized to do one thing, and that's prosecute or defend litigation. And without specific authority, can't normally settle, can't normally engage in other, it can't do a lot of the things that a special rep can be empowered by the court to do. And later in the statute, further down, we talk about the idea that the court is going to shape or contour the authority and responsibility of the special rep depending on the circumstances of the case. And if we're going to do that, then why have a GAL allowed for at all?
I think we retained the GAL because in some circumstances in estates, it's appropriate to have a GAL. So I've had a number of cases where GALs have been required because there's a separate federal case. In the federal courts, you look to the state for a GAL. So Matt, would those kinds of, I don't have enough experience because it's never been used before.
Well, let me ask our judges, because they would see these. Do you see merit in the choice between a guardian ad litem and a special representative?
This is Judge Burton again. I like the special representative. I think it has more flexibility. As Brooks was pointing out, it's more nimble. You don't have to necessarily go through the same process that you have to go through for a guardian ad litem. So I like having that option.
And this is Judge Cobb. With the guardian ad litem, I think that it was Matt that was talking about the limitations, authority to settle, authority to receive funds, all of those things. So I really like the idea of the special representative, but I don't, I think Heather's point is well taken. I don't know if we want to tie a judge's hands saying I can't appoint a GAL.
Yeah.
This is Judge Donahue. I agree. I think the special representative, I agree with Judge Burton. I'm really in favor of a special representative for a variety of things I've seen in probate cases. And I think because it's the easier of the two, that's kind of going to be the default for a state, for probate attorneys, because it's going to be more flexible, and it's going to be something that is going to have, I think, maybe a little bit more authority within the context of probate. But I wouldn't take out the guardian ad litem either, because I think the problem you run into is a guardian ad litem has powers that would extend beyond the probate case that may be necessary to affect something on behalf of that person. And if we don't leave that as a more cumbersome but maybe more necessary alternative in some cases, we may wind up with a special representative who, when they go to try and affect some legal interest of that person outside of the probate matter as a necessary part, is going to find they lack the authority.
Okay. So it sounds like there's no good reason. While special representative may be the preferred option in most cases, there's no particular compelling reason to exclude the guardian ad litem provision. So I'm good with that.
Lori Ann, it's Heather. Just as a drafting question, do we need to say and or? Because there are cases where I have been appointed as both the guardian ad litem and the special representative.
Where are you?
I'm in section
between A and B.
Or can mean and.
Okay.
We don't use and or in statute, or can always be just or it can be and.
Okay. We don't need to say or both.
Maybe a comment to that effect, but I do know that is the legislative council style.
Yeah, that makes sense, but it's helpful to let a court know they have the ability, not that the court wouldn't do what it wanted anyway, but I just like the idea of the ability to appoint them as both. One is the guardian ad litem for maybe the third, the outside case, and the special representative for the probate case.
What if we change the lead in to that? So it'd be at the end of subsection 1, before it drops into the sub A and B, it would say the court may appoint one or both of the following.
Great.
That's good.
Well, you potentially, well, no, I mean, you potentially run into the situation where you get into a fight where somebody says, well, so-and-so can be the GAL, but I should be the special rep. I mean, this is the sort of dysfunction that we deal with all the time.
Yeah.
Agree with Matt. If you're going to do that, it needs to be one person can be appointed to either or both roles for just that reason. Same reason we don't like co-PRs. It just creates chaos.
Yeah, there's too much potential for disagreement. Yeah, I agree with that.
To be clear, I mean, the special rep as a vehicle is flexible enough that the court can, I mean, and understanding Judge Donohue's comment, which is appropriate, with understanding that other courts may, you know, a court in a separate civil action, state or federal, may be looking to whether or not this person has the authority to act on behalf of this person who needs representation in this matter that is not the probate. You can certainly craft an order appointing a special representative that makes it clear that this special representative shall be considered a guardian ad litem for purposes of this other civil litigation or this other cause of action which is not yet filed but may be in the future.
That's great, but the rules for appointing a special rep are now entirely different than appointing a GAL. The ORCP 27 rules for GAL are pretty complex comparatively.
Well, I guess that's a drafting issue then. We can let Lorianne take a stab at that. Somehow we want language in there that would authorize the court to appoint the same person as both guardian ad litem and as a special rep. So concept is there. I don't think we need to draft the language. Let's see when we get back. Let's go on to 4. Basic effect. So far, sub 3, we've got our litigator subcommittee that's going to take a stab at telling us what that needs to say. I'm sorry, sub 2. Sub 3 we just covered. We'll get just a change to that so that it's clear that the same person can be appointed in both capacities. Section 4, basic effect of representation.
Can I back up? This is Judge Cobb. Can I back us up to 3 sub 2? That it's talking about the court may appoint a guardian ad litem or special representative to represent more than one person or interest to the extent no conflicts exist. Right. So a lot of times what I've seen happen is I'm asked to appoint somebody at the front end and everybody's holding hands singing Kumbaya, and then a conflict occurs down the road. And everybody wonders why I made such a stupid decision appointing one representative for the 3 children. So could we have some kind of language that says if a conflict arises, this gets changed, as opposed to I have to make findings that, you know, and everybody's got their hair on fire?
I think that sounds like a good add, because you're right, that conflict may be apparent at the beginning, it may not be apparent, but if ever a conflict comes up, we should have the ability to assign a new guardian or a new special rep. So unless there's objection to that, it seems to me probably again asking Lorianne to devise some language that would just say that after appointment, if a conflict occurs or arises, the court can appoint a new guardian ad litem or special representative to protect the interests of the particular parties.
And I think the special representative or GAL has the obligation to inform the court, and then, because a lot of times I'm the last one to know.
Sure.
So is it mandatory that the court, if a conflict arises, is it mandatory that the court appoint somebody else to act as GAL or special rep with respect to that particular issue? Or how does that, procedurally, how do you see that playing out?
What I've usually done is when the conflict somehow bubbles up, that I will appoint a new special representative for Johnny, and leave the old one with Susie, or, you know, whatever, to move it forward and to resolve whatever the issues are. And usually I usually have appointed special representatives as attorneys or somebody with specialized knowledge that can say, this is turning into a problem and giving me a heads up.
So is it going forward for the duration of the probate proceeding that there would be a new special rep or GAL for Johnny versus there would be, it bifurcates for the remainder of the proceeding, or is it just with respect to that one issue?
I think I'm trying to think, usually it's until whatever it's usually the inheritance, who's getting the money or whatever it is. And once that's resolved, that's when, in my experience, the attorney wants out and doesn't want to hang around longer.
Okay.
And is it a may or a shall? I mean, do we give the court discretion? I mean, are there cases where it may just not merit the appointment of a different one, or is it shall in all cases if there's a conflict?
I always think it's may is a good idea. The only place that I've had personal experience with this popping up is guardian ad litem's for minors in like a wrongful death proceeding. And sometimes very cost effective at the beginning to have one lawyer who is standing in the shoes of the minors on the personal or the wrongful death proceeds. And then when it becomes a division issue and it's not clear what the division should be at that point, then the court could figure it out. But almost, I mean, the challenge is that with those guardian ad litem's, I don't want to say shall, the court has enough judgment and discernment to know, okay, all of the kids need a separate GAL, or this one person does a good and fair, balanced job of telling the court what each child's situation is.
And maybe it's the special representative shall inform the court, and then the court may.
Yeah, I like that.
What is do we need to address what the penalty is if the special representative doesn't inform the court of the conflict, or is that resolved just in general in litigation?
This is Brooks. I would generally think that unless there's literally no one else in the case who cares about the minors or incapacitated persons being represented, somebody's going to bring it to the court's attention. That's not been an issue that I've seen.
But is the question, what, can the court thump the guardian or the special representative somehow for violating some obligation, some duty?
I don't want to put a penalty in there. I think the court knows when and if it should do something. And the reason I don't want to put a penalty in there is you could have wrongful death and mother of child 1 and a different mother of child 2. And sometimes the GAL becomes the mediator in that situation. If somebody doesn't like it and they're acting unreasonably, I just don't think that that's something that we
Yeah, that's fine. I wasn't suggesting it. I was just asking. Okay, are we ready to move on then? At least
I got one.
John.
I think 2A could be deleted. 2 deals with a special representative representing multiple persons. 2A is singular. 2B is perfect. But how do you shift from conflicts of interest among the multiple represented persons to a conflict of interest between the special rep and the person being represented? It's, that doesn't fit in there.
I don't disagree with you, John, but I think that what we were looking for was the conflict of interest between the fiduciary and the interest being represented versus the interests of the persons represented.
Well, I agree with that, but that doesn't arise only when you have multiple interests being represented. That would be an issue every time you're going to be a special rep. Even if you're just going to represent one person.
2A is sort of a vertical conflict between the rep and the person being interested. 2B is a horizontal conflict, right? Between where you have conflicts now between the multiple individuals that are being represented by the single guardian or special rep.
Correct. It's
So
not
they
said
seem
well.
to both have merit on their own.
John's point, though, is that sub 2 is talking about a special rep being appointed for multiple persons.
Oh,
and
okay.
So it needs that there's a difference between
well, but the drafting fix is very simple. 2A could simply say the guardian ad litem or special rep and the person or persons or interest or interests being represented, and that harmonizes it with the rest and still saves the concept.
But John's point is 2A deserves to exist even if the representative is being appointed for a single person.
Right.
And that's why I'm making it disjunctive, person or persons.
Well, but that doesn't work though with the lead-in to the language, the 2 in 2 where it says may appoint a guardian to represent more than one person.
Point.
So then that change to A doesn't really flow from that introductory clause.
Fair point.
This is
be like 3.
Yeah, this is Lorianne. I can redraft this. I don't think we need to spend time on this.
The only point I would have in redrafting is I don't want to stray too far from the language of 130 because I like the idea that the concepts are related.
Okay.
Okay. All right. Moving on.
So Lane, before we move to section 4, sorry.
No, it's all right.
I think it might make sense for us to consider section 5 first, because we're also talking about representation by sort of a different group of people. And it seems to me like organizationally, it would be good to have an idea about that before we go on to talk about the effective representation.
Okay, fine with me. So then we'll go to 5. Let's not forget to come back to 4. Representation by fiduciaries and parents to the extent there's no conflict of interest. Well, okay, so here the conflict comes. Here's the conflict issue between on a one-on-one. So to the extent there's no conflict between the representative and the person represented, or among those being represented, and agent having authority to act with respect to a particular question or dispute may represent and bind the principal. A trustee may represent and bind. Okay, what's going on here?
So remember, we borrow this from 130.
Yeah.
And we have 2 issues to think about in 5. And so in 130, it's trusts. And in that concept, we have this idea that parents can bind and represent their minor children. And so I think we have a public policy question about, do we want the same concept in probate? The difference between probate and trust is that in a probate, usually the interest is more immediate, not necessarily, but usually the interest is more immediate. And in trusts, it's usually, we like this sub 4 that a parent may represent and bind minor and unborn children, because it says grandma's trust says all to child for child's life, and at the end of child's life, all to grandchildren. Or if child doesn't survive, then to grandchildren. And so we like that parent as the interim rep. So for me, the public policy question is, do we want the same kind of ability for a parent to represent a minor or unborn child in a probate?
I like that idea, as long as the interests are not, adverse, opposed, et cetera. So, we need to have the minors represented, and appointing a GAL in a purely administrative matter where things aren't going wrong just seems like make work. Did I stun everyone? Everyone's quiet.
Makes sense.
This is Judge Cobb. So does it have to rise to a level of no conflict of interest that grandma left the $400,000 to child as opposed to ne'er-do-well son, father of child? So does that allow the father to get his hands on child's funds?
Well, I think it's only a conflict if son wants to challenge that aspect of the probate documents. You're raising a separate question of does the court have discretion to refuse to apply the UTMA when it's time to distribute to dad as presumptive custodian for minor? I guess.
Well, under 4, a parent may represent and bind the minor or unborn child. So I'm the parent and I'm saying, you betcha, I want a partial distribution right now because I've got my eye on a, yacht that I want to buy or something like that. Obviously, I'm not telling the court that I want to buy the yacht. It's all for Johnny.
Yeah, but again, Brooke's point is that the money doesn't go directly to the parent as custodian unless it's under the statutory minimal, it's just a de minimis amount. I mean, so that's why I think it's a public policy question.
Yeah, nothing about this section would obviate the need for the establishment of a conservator for for a minor beneficiary once the money's actually distributed.
That presumes that UTMA is not going to be employed, because I think it could be here.
Yeah.
I just have a question under section 5 at the very beginning, where there's no conflict of interest between a representative and the person represented. What's the definition of is this the special representative we're talking about, or any representative?
Yeah, that was my question.
Sorry.
No, it's a good question.
Well, and I have a related question to that, and I don't know if we have to answer it right at this moment, but how is there a process for having these representatives recognized by the court as being entitled to receive notice? My main thing is you want to have an adult receiving notice for a minor beneficiary, just the usual notices in probate, and then other things that can happen.
Yes, let me go back to both those questions. I think Judge Cobb's question. How does this section relate to special representatives and guardian ad litems? Because it's right in the middle of that sequence. So what's going on here?
If you look at ORS 130, it's the concept of statutorily saying these people actually do have the right to act on behalf of a person in a trust. Even though they're not a trust beneficiary, in their fiduciary, we recognize the fiduciary authority of these persons.
Without appointment, formal appointment as a special representative or a guardian ad litem.
Correct. And so that also goes right to the public policy question.
Okay. It just seems like in the order, and this again is maybe a Lorianne issue, but it seems odd to put this right in the middle of the special representative. Well, maybe I don't know. Organizationally, it confused me when I read it.
So you think this should be 4 and 4 should be 5?
Maybe, or before even 3, because 3 talks about starts us down the road. So I just, however it is, we need to make it clear that this is outside of the guardian ad litem and special representative provisions. So whether it's notwithstanding or I'm not sure. But so that I understand, I mean, that apparently is what's going on, correct?
Correct.
That's correct, but I also think we want to decide in section 4, does section 4 apply to both these kind of more informal types of representatives and the special representative? And so I like the idea of moving this before the guardian ad litem and special representative section, because then that kind of sets it apart as first we have this.
So then what would be the standard with with Section 5, what would be the standard that the court would be looking at in Section 3 to ever appoint a special representative?
Well, if there's a conflict of interest, or if you just don't have anyone who is a suitable person to represent, or if you need somebody with special expertise.
Because in Section 3, all we're saying is the court may be inadequate.
Right. And Section 5 doesn't really address adequacy.
So do I have to make a finding that the dad's a drug addict or a spendthrift or just an idiot?
This is Heather, Judge Cobb. I think that's one of the best questions about this statute is, at what point does it shift away from a parent representing and binding the minor or minor child? At what point does it shift away, and how do we know that? And in the ordinary case where, you know, grandma makes a specific gift to each grandchild, it's just really nice and clean to know that when you give notice to the parent that it's effective notice.
Right.
The challenge is on those cases where you do have the potentially inappropriate parent and you don't even know. I mean, the lawyer doesn't know, nor does the court.
Well, you still got to have, that's got to be a safe harbor if you don't know and nobody knows. So I think it would have to require some sort of determination. And, you know, this talks about to the extent there's no conflict of interest, and maybe we need to add here, you know, also a provision, you know, unless the court finds that the fiduciary parent is not capable. I don't know, because otherwise adequacy is really not addressed here. And so this looks like it would trump your special representative statute if there's a parent who says, hey, I'll do it, and there's no conflict, but there's a real question about their competency.
This is, and I also had a question about it being limited on Section 5 sub 4 to just if a conservator had been appointed, because you could have a guardian appointed and there's no money involved, so a conservator hasn't been appointed yet, but a guardian's been appointed because the parents aren't, there's something going on there that those, yeah. So is that something that needs to be addressed here as well?
We could say a parent may represent and bind the parent's minor or unborn child if a special representative, comma, a conservator, comma, or other fiduciary for the child has not been appointed. And that would take care of both the guardian, I think that would include guardian ad litem, because what I don't want to do is create conflicting statutes where the parent says, I have the authority under Section 5, and then the court saying, or the lawyer saying, I appointed Mary lawyer under the special rep statute, so you don't have any authority. I don't want that.
I think I like that. Judges, what do you think?
I like it. This is Judge Cobb.
Yeah, because then this puts it in the context of special rep and guardian ad litem. It doesn't trump it.
This is Judge Burton. It took me a while to find my mute button to turn it off, but I'm good with that also.
Okay. Folks, I'm going to declare that the win for the day.
Wait, can I add one small thing to that? I love the changes that Heather suggested for subsection 4, but perhaps those changes should apply to all of 1 through 4, not just subsection 4.
Oh, okay, good point. So maybe it goes up in the language at the beginning of that section. To the extent there's no conflict of interest and no special rep, guardian ad litem, conservator, or guardian has been appointed, something like that.
I don't know that Jennifer, would it belong with a trustee? I mean, the trustee holds legal title, and the same concept for the PR.
Well, but if you have a special representative appointed, do you want those roles in conflict?
Yeah, but I don't, how could you appoint a special rep for a trustee who has capacity?
Right.
You would appoint a special rep for the beneficiaries of the trust or the person in the estate, not the fiduciary.
Well, wait a minute, this is not right, because the beneficiaries of the trust aren't involved in the probate. The beneficiary of the probate is the trustee.
Right, right.
And the same thing with the PR. If you got a decedent's estate that is the beneficiary, the PR is the beneficiary. The beneficiaries of that estate are not beneficiaries of this estate.
That is true.
So,
Right, I
this
agree
is-
with that, but I do think that the agent issue could be a problem.
Yeah, this is Judge
Well,
Donahue.
no, it's not, because there is no agency. The trustee and the PR do not represent the interests of their beneficiaries. They are the beneficiaries.
John,
Now,
she's
if
talking
they're-
about one.
She's talking about sub one.
And she's talking about a case that I had that went up through the Court of Appeals where there was a dispute between the conservator and the guardian and the agent. And so I can see it arising where somebody has the power under a power of attorney and there's issues about them abusing that. But
Okay.
I'm not sure this is the place to fix that.
Let's just make notes of the conversation about 5. Let's not change anything yet. We'll pick this up next time. I've got to zip to another Zoom meeting that I'm late for. So we've got our marching orders on 2. That's going to be our litigators assignment. 4 we've looked at. No. 3 we've looked at. Going to have some changes there, and we'll pick this up at our next meeting.
Yeah, I'll send out a scheduling link for approximately 2 weeks from now. If the litigators subgroup wants to communicate with Lori and I to make sure we get those documents out to the group, Lori Ann and I, to make sure those groups to the group before then, that'd be great. Other questions, just let me know. Thank you.
All right. Thanks, everybody. We'll see you next time.
Bye.
Bye.